Okay, welcome once again. My name is Julius, and I'm here to discuss the concept of the 1902 Order in Council, which is also a topic under constitutional history. So, what do we really need to know about the 1902 Order in Council? So, after the signing of the 1900 Buganda Agreement, we saw other different kingdoms also agreeing to sign agreements with the colonial government. And now in the 1902 we had what we call the Order in Council, because the 1900 Buganda Agreement, all those other agreements were just binding the different kingdoms which signed it, but not Uganda at large. So in the 1902 we received the first formal legal document in form of a constitution, all laws telling people what to do and what not to do. So this is the 1902 Buganda Agreement, and it was made in the 1902. And this 1902 Buganda Agreement also had different clauses, all different. Some people call them sections, and I'm going to discuss the main sections and how they have also shaped the political, constitutional, and economic development of Uganda. So I'm going to start with section 1 of the 1902 Order in Council, and that section provided all the section also provides for the demarcation of the boundaries of Uganda. And the 1902 Order in Council was like for the entire Uganda, not for a specific region, but it was for Buganda at large. So also Article 1 of the 1902 Order in Council started with demarcation of the boundaries, and 5 regions were created. That's to say, the Central region was created. We had the Ludrof region, which was also created. We had the Nilo region, which was created. We had the Western region, which was created. And we had the Kingdom of Uganda and its islands, which was also a region created, making them 5 regions of Uganda under the 1902 Order in Council. And now, what do we really need to know more about the 1902 Order in Council? Section 4 provided for the position of the commissioner, and it gave commissioner powers all to act as the head of the protectorate on behalf of Her Majesty's government. So under section 4 we see the commissioner being appointed to be the head of this protectorate. So that is specifically what section 4 provided for. Then we are going to go to section 7 of the 1902 Order in Council, and section 7 of the 1902 Order in Council vested all the crown lands in the hands of the commissioner. He said the commissioner was acting as the head of state by then, and now under Buganda Agreement we saw that land was divided into Milo land and Crown land. So the Crown land now was vested in the hands of the commissioner. So the commissioner had control over that land. Now when we go to section 8 to 10 of the 1902 Order in Council, here we saw the commissioner being given power to make laws. And now the commissioner was given power to make laws for the good governance of the protectorate. So which means he was the executive, at the same time had the parliamentary powers of making laws, because he was the one supposed to make laws governing the protectorate. And now in the of making these laws, he also applied the laws from the United Kingdom, but he had the power to make them applicable here in Uganda. Then another key section in the 1902 Order in Council, what we really need also to know is section 15, and this is very important because section 15 is classified into 2. There is subsection 1, section 15.1, which initiated the courts of law here in the protectorate, and it established the Her Majesty's High Court of Uganda. And then under this section, magistrate courts were also created in Uganda. And now who had the powers to appoint the judges or the magistrates on these courts, all in these courts? So the commissioner had the power to appoint, and also the commissioner had the power to disappoint the magistrates in these courts. And now under subsection 2 of the same order in council, 1902 order in council, it answered the question which kind of laws were going to be applied in Uganda. And this is the section which provides for the reception clause, and this is a key section which everyone needs to know in this order in council. So provided for the reception clause. The reception clause was like what kind of laws which are going to be applied in Uganda. And the reception clause provided that all the laws which were made in UK and the laws which were applied in the other protectorates of Uganda of the United Kingdom, we are going to be directly applied in Uganda with few modifications to fit the Ugandan circumstance. And that's how we received the Indian Penal Code. That's how we received the Evidence Act and all other laws from United Kingdom and other protectorates of UK started to be applicable in Uganda. Hope also that one is clear. That is the provision which brought in the different laws which are still currently applied in Uganda. For example, common law, for example, those statutes of general application in UK, they are still applied here in Uganda. Then lastly, section 20 of the 1902 order in council provided for the repugnance clause. So also we need to pay keen attention on this section of the repugnance clause, which is section 20. So when they brought in new laws all under reception clause, another question came in, because they found that people in the protectorate, they had their customs which they used while resolving disputes. So the colonial government agreed that for matters involving natives, their customs are going to be applied provided that they are not against natural justice, morality, and good conscience. What does this mean? That all customs which are not repugnant to natural justice, morality, and good conscience, all what a white man considered to be right or righteous, they were not applied. Those which are repugnant were not to be applied. Those ones which were not repugnant with the provisions of natural justice, morality, and good conscience were to be applied. And this provision resulted into a number of cases which were determined later. For example, the Ara versus Amkeo case, people should get to know what happened in this case. Best Kemgisha versus Mebo Komuntale, Gwao bin Chilimo versus Sunda bin Ifuti, and Mwenge versus Migade, Bruno Chihuwa versus Namazi. All those cases, you need to really give them keen attention under the aspect of repugnance clause, because such customs which were against natural justice, morality, fairness, and good conscience were termed null and void. All were not to be applied. But customs which were okay with the aspects of natural justice, morality, and good conscience were to be applied. Thank you so much.